The cash for keys process has changed in the state of California. We're going to run through exactly what happened in a recent legal case that changes the process for cash for keys. If this process isn't followed and the tenant doesn't move out, a landlord may not be able to legally evict. Hey there, Christian Walsh, real estate agent with Wire Associates. We've been helping renters and landlords understand their rights before things go wrong. And remember, we can't give tax or legal advice, but for the most honest and up-to-date real estate advice, subscribe to this channel. During the global financial crisis, we were assigned REO listings as an REO agent. One of our first jobs was to go and knock on the door to figure out exactly who was living there. Is it vacant? Is there a tenant? Is there a previous owner? Once we figured out that it was occupied, then it was time to come up with a cash for keys arrangement to get that person to move out. So what is cash for keys? It is an agreement for an occupant to turn over possession of a property by a certain time in exchange for cash. There's nothing shady or wrong about cash for keys. It is a legal thing to do. And the other thing to note is that in some cases, there may be local regulations related to cash for keys, also known as tenant buyouts. So make sure you understand your local regulations. For example, LA properties that fall under the rent stabilization ordinance, they have a specific form and process for the tenant buyout that must be followed. When would you use cash for keys? Well, there's actually quite a few times it would make sense. So for example, if a tenant isn't paying rent and you want to get that tenant out, of course you can use an unlawful detainer, or you can attempt to use cash for keys to get them out sooner and for less money. Another option, as we discussed, for example, when a home was foreclosed on, we would use cash for keys to get the occupant out. Maybe a tenant is on a lease and the landlord wants to sell, but wants to sell it vacant, or maybe move their family in. Cash for keys or a lease buyout would be one option to get the tenant out. Otherwise, the landlord is going to have to honor that lease through the end. Another use would be squatters or unlawful occupants in the property. Of course, you'd hate to have to pay them to get them out, and you'd rather go the legal route, but it's easier and cheaper potentially just to pay those folks to disappear. And then even if a tenant is month to month and you can give a notice to terminate tenancy, for example, a 60-day notice, you may be able to go ahead and use cash for keys to get them out sooner. It may make sense in your situation. As for who can actually pay the tenant buyout amount or the cash for keys amount, it's negotiable. Usually it falls on the landlord's shoulders, but if there's a person buying a property and they would like to go ahead and get that tenant out, a buyer could go ahead and pay the fee for the cash for keys. Why would they do that? Well, if they're getting a good enough deal, it may make sense for the buyer to do it. Of course, in order to do this, you need permission from the owner of the property. You can't just negotiate it on your own and pay for it. So what changed in the state of California related to cash for keys agreement? It was this important case right here. We have a link below so you can run through it. I'd like to thank Nick Squidzy on YouTube for pointing this out and sending this over. This was very important and led to the changes. It's very recent. Ultimately, it was decided in September 20th of 2022. In a nutshell, and again, I have a link so you can go ahead and read through this. The Basilius family, Sam and Susanna, went ahead and signed a form of a cash for keys agreement. And in that cash for keys agreement, they said they'd give up possession by a certain date in exchange for a certain amount of money. Well, that date came, they did not give up possession. So the next logical step was to move to unlawful detainer. Seems pretty cut and dry. They agreed to the date, didn't move out. Well, it's time to evict. Well, not so fast. What ended up happening is the Basilius family fought back and said that that agreement that they signed was not a just cause at fault reason to go ahead and move forward with an eviction. Under the Tenant Protection Act, which this property falls under, we've released plenty of content on that. And even if a property is exempt from the Tenant Protection Act, we're going to recommend that you still use the new form for cash for keys. Under 1946.2 in the California Civil Code that I'm floating over right now, it gives the reasons a tenant can be kicked out of a property, whether it's at fault or no fault. So if you look at this list here, which is the at fault reasons, and by at fault we mean that the tenant has done something wrong, the agreement that they had, and every cash for keys agreement, wasn't set up to fall under this list of allowable reasons to kick somebody out. So the tenant was able to fight back. The big change in the cash for keys agreement is the tenant is now making a written offer to surrender the property that's accepted by the landlord. Now, if a tenant doesn't move out after signing the agreement, they can be evicted for an at-fault reason under letter K. They can be evicted because they gave up, they offered to surrender and didn't move out on time. So that's an important distinction, and it changes the way you use a cash for keys form. We're going to explain that next. And don't forget, we're real estate agents based in Southern California with a valid listing agreement. We can help you with cash for keys. So now the cash for keys form has this handy dandy cover sheet. You don't deliver this. This is just for the person delivering the cash for keys agreement. And what's very important is it says it should be given to the tenant to make the offer to the housing provider by signing it first. Tenant needs to sign it first. Then the housing provider, the landlord, should then accept the offer by signing it second and returning it to the tenant. That process is very important because the tenant has to make the offer and the landlord has to accept it in order to be able to use K under 1946.2 to be able to evict the tenant if they don't move out. The other important warning is if there's local rent or eviction control, of course, you have to know if there's any local procedures in place for tenant buyout or cash for keys. Those must be honored. And then this talks about the tenants not leaving. So here's the new form itself to use as of April 2023. This is the form you're going to use. And there may be a revision, so we'll do another video on that. But now here's the big change. It's an offer to surrender the premises in exchange for cash. It's not cash for keys, it's cash for the offer to surrender the premises. It runs through that right here. And again, don't forget the tenant has to sign this first. So this form actually has the tenant offering to the landlord to leave in exchange for the payment, which you put here. And it's going to go to whom? You're going to want to have all occupants reflected on here and signed by all occupants. And there you're going to put the move out date here. Foreclosure, this section here talks about foreclosure and previous owner or tenants or other occupants. Slightly different process, potentially different amounts of time if the property is goes through the foreclosure process and is occupied by a former tenant. The obligations, the tenant must continue to maintain the property and they still have to allow the landlord in to show, etc. The utilities have to be paid for. That's all laid out here. Section 5 talks about limitations on payment. Essentially, if you show up to do cash for keys on the day they move out, you give them the cash. If it's in broom swept condition, utilities have been paid, etc., give them the money then and there. If not, you're able to not give them the money, deduct any of those things that they were supposed to have done can be deducted, and the balance can be given to them at a later point in time. No tenancy created. This doesn't add any special layers of tenancy created by agreeing to it. Some occupants, a landlord may refuse to acknowledge as tenants, and this is not creating that tenancy. And then if they don't vacate, then it can move to unlawful detainer. The other important thing about payment is it'll be given on the move out date like we talked about. It'll be one check and it'll be made out to everybody. All the adult occupants need to sign this. And once it's signed by all the occupants, then the landlord will sign the agreement, and that will meet the letter of the law. Let us know your cash for keys questions below, and tell us your stories. Have you negotiated cash for keys, and how did that go? Subscribe to our free weekly email newsletter so you don't miss any updates on cash for keys or anything else for renters or landlords. Thanks for tuning in. This has been Christian Walsh, real estate agent with Wire Associates, and we can't wait to hear from you.